Good morning, everybody. So we'll start now. So today we are here to discuss the recent Supreme Court's judgment on the electoral bond scheme, and we have with us senior advocate Harish Narsappa, who is also the co-founder of Daksh, and he's exclusively worked on a lot of promoting electoral democracy in Karnataka, and so we will start, and he practices in various courts in diverse fields of law. So we'll start with an introductory background in which the electoral bond scheme was introduced, and then the judgment and what that means for the general elections, the upcoming general elections, and also the future of electoral democracy. So let's start.
Sure. So I know it's a. I was thinking about whether I should start on a positive note or sort of a grim note about how electoral democracy works. And the positive note is, everybody seems to. Many of us think that the electoral bond scheme has now been declared unconstitutional, so it seems to have solved a lot of problems. Then the consequential question is, what are the problems it has solved? And then if you start unraveling the different problems that people working in connection with transparency and clean elections have been fighting about, those questions still remain. So that's the sort of grim part, and I'll explain what that is. So electoral bonds were just a form of funding of elections, right? But the issue of the enormous amount of money spent in elections and how do we control that, or how do we regulate that, that remains. Okay, that has not gone away. That question is unanswered, and that's the larger question we need to grapple with when it comes to electoral democracy. So the good news is electoral bonds, the scheme is being found unconstitutional, because clearly there were a lot of problems with that, and we will discuss that in detail. But Mridula said, let's start with the background. So I have been working on elections as part of Karnataka Election Watch since 2006, right? And so that's a very small part of the overall election scheme, right? And it arose the Karnataka Election Watch and election watches across the country were formed following ADR's success in getting the Supreme Court to direct candidates to declare their assets and criminal records. And once the declaration was there, they said, how do we communicate this to people? Because the candidates were filing the affidavits with assets and criminal records, but how do we make sure that people know about it, right? And then so what we used to do and what we still do is gather the affidavit and collect the data and release it just before the election day, because the candidates file affidavits only in that window, right? So there's a nomination date, filing nominations, and then withdrawal of nominations, and only for about 2 weeks, just over 2 weeks is when the actual candidates who are contesting in each election, right? So, and that's where the money problem also comes. I'll come to that later. So we started basically distributing this information in the form of releasing to the media, and then also using ADR partners who are various groups who are part of election watches in different states, and then we used to sensitize people with the information there. So from 2006, when I started getting involved, one of the things we used to highlight was how many crorepati's are contested. Right? So clearly we thought money is a factor, and people need to know who are the candidates, how much money they have, and if they had contested elections earlier, then how much has their wealth increased over the 5-year period or 10-year period, however long they have been contesting elections. And just as as an indicator of the importance of money, now in fact we feel using the word crorepati is meaningless now, because pretty much everyone who contests elections now is a crorepati. And there is an economic angle as well. Even if you have a house, say in central Bangalore, which you may have got by inheritance or whatever, you are a crorepati to declare that asset. So there is some element of a false positive, so to speak, right, in terms of calling people crororepatis, and somehow is that wrong or not? So that's a debate that many of us dealing with this form of sensitization are having. Whether we should we invent a new term, sort of how has the money been earned, for example? Is that a consideration? All of that is there. So since then, if you look at from 2006 until now, so almost 18-19 years I've been looking at elections closely. One of the primary markers of elections is money. Okay, and I know ideology is another thing, and ideology has assumed importance in the last 10 years, whereas before that it was not so important, right? Because now it's more of a marker now than it was, say, 20 years ago. Okay, and money was a big factor, and the overwhelming, importance of money in elections is staring us in the face. And the only institution actually that believes that in India elections are free and fair is the Election Commission. And why do I say that? And I say it's not a joke at all, and it's quite serious, because the Election Commission, for example, fixes limits on how much candidates can spend in each election. For MLAs, it's a particular amount. Now it's, I think, in Karnataka it's about 40 odd lakhs. So different states there are different numbers, and for parliamentary elections it's now I think about 75 or 80. Earlier it was less. And the people who declare candidates who contest elections are supposed to declare after the elections are over how much they have spent. And it's a joke, because the people who have spent the most declare the least. And everybody knows, that people have spent a lot of money, but we are not able to regulate that. And it's a failure of many things. Right? It's a failure of the income tax system. It's a failure of the election commission system. It's also a failure of the legislature to evolve a proper framework for monitoring that. Because what happens after elections? So during elections, the election commission is directing the administration to behave in a particular manner, and after elections, they don't have that power anymore. So the power to, or the intent to prosecute people for violating, sort of the limits of expenditure, the election commission doesn't have an interest anymore, because the people who are supposed to follow that case and pursue this case is the local administration. And why will they do it? Because local administration is now under the control of people who have either won or influenced by people who have lost, because they are players in the electoral system. A party which loses this election may win the next time around. So there is no incentive to push for prosecution of breach of electoral expenditure limits. I think that's the reality. So what electoral bonds deals with, and the constitutionality or now the unconstitutionality of the electoral bonds, it deals with only one particular question as to how are political parties raising money. Is it coming through cash, which is a big part of our country, or is it coming through some other form? That's really the only one. So the larger question of money and elections is not solved. Okay. So before we all sort of get too happy with the electoral decision, how does this influence the conduct of elections and the sort of the level playing field in elections? There's no level playing field. Like if some of us in this room want to contest, we don't stand a chance in hell. Right? And why is that? A, we don't have the electoral machinery of the large political parties, and B, we can't compete with the money power that they have. So the barrier to entry in elections is extremely high. I mean, there are exceptions. Over the years, there have been exceptions when a person who's worked in the constituency, who's well known, comes in and without spending that much of money does win. But even the so-called clean candidates who have won over the last 20-25 years have spent money. Okay, and have spent money beyond the expenditure limit. Expenditure limits are sort of meaningless. Expenditure limits are also sort of irrelevant, because it costs a lot of money to contest elections. And then of course it raises a question: if you are spending so much money in contesting elections, how do you recover that? Because nobody is doing it out of goodness of their heart, right? So that is a question, and that one portion of that is dealt with in this judgment, because they talk about quid pro quo and why will people give so much money is a question the Supreme Court does ask and answer in a way. It's saying that there's always quid pro quo, and it's, if you read it in a way, it's very cynical. It's a sad story, a sad narrative about the sad state of affairs of electoral politics. Okay, but it's also the reality. It's not only our country, right? I mean, worldwide people are grappling with how do we deal with this enormous amount of money involved in elections, and it raises questions about the mode of democracy as well. Anyway, that's because you asked me for a background, and I didn't want to only sound a positive note, because it's not that positive. Okay, and let's be very clear about it. It's positive only because it's a small victory in asking for transparency. Okay, and electoral bonds, what did it do? It sort of created a big, nice wall around the method of funding. Okay, so whatever gains we had because of the efforts of ADR, PUCL, and others in the Supreme Court since 2002 onwards, most of those efforts were in a way defeated by the electoral bond scheme. Okay, so to that extent, because the scheme is now dismantled, and until the next ingenious method is set up, and it will be set up. Let's not be in any sort of under any illusion that a new scheme will not come. I mean, what form it will take is another issue, but the fact is, political parties need funding. That's the first fact, and that's a reality. Okay, and how do they get funded? The romantic notion of everybody contributing 2 rupees doesn't work. Okay, it doesn't work. So there will be large donors to political parties, and large donors again don't give out of the goodness of their heart. I mean, maybe some do. I mean, we should not be so cynical also. I mean, if we become so cynical, then it's difficult to sort of continue having this discussion. People do give because they believe in a particular idea of how society should progress. So there's people do donate out of that concern, but there's also a significant portion of electoral funding is around quid pro quo. That's a question that this judgment sort of deals with, and that's at the heart of the judgment, right? That was the core of the issue, right? Unfortunately or unfortunately, the legal victory is not directly on that, but it's around privacy, right to information, etc., which are also important things. But if you ask me, well, we should not grudge the victory that has come, because it was a very difficult victory because it took such a long time. A, and B, the judgment does lay down, very important principles that will be useful for further development of law on certain kinds of rights. But it could have, the judgment, for example, could have dealt with this issue head on about electoral funding and political party funding. It didn't. To be fair to the judges, that was not what they were asked to do, because the petitioners also raised only a certain set of questions, because their goal was to ensure that this scheme goes away, and that has happened. Okay, so that is the background. The background is how do we fund political parties and how do we fund elections. Okay, and that's happening, and those questions remain. So you also asked what impact will it have on the forthcoming general elections. I think while I hope it will have some impact, I think having seen so many elections, I don't think this judgment is going to have any impact. Okay, because parties know how to fund themselves, parties know how to figure out, parties know how to make sure that they have enough cash to contest elections. Because the people who are contesting elections and who hope to win, or even people who know they may not win but they have a good chance of giving a close fight, are happy to spend, are happy to beg, borrow, or extort or whatever, and fund their elections, because they know they are able to recover this money, and I think that is the key, right? So I think I've addressed most of the
Yes.
points that you asked,
Yes.
the pointers that you wanted to have as a background
Yes.
to this judgment.
Thank you for that, sir. There are also some people here who speak Kannada, so if you can like mix English and Kannada, it will be very nice.
Sure.
So yeah. So the next thing here would be the judgment very extensively discusses how economic inequality is starting to really affect political equality now. Like how first we were like focused on representation of people from like all kinds of diverse backgrounds. Now we're also like this judgment brings us to question about the influence of these communities or diverse communities, right? So that was very interesting, and I think it could be further developed. So these are principles like one person, one vote is being diluted in the name of like when there is like what does one person, one vote mean when there is so much economic disparity, right? That's also something that this judgment really it touches upon it, even though it doesn't answer it. But I think, what do you think the future? How can we build on this jurisprudence like established by this judgment? How do we build that forward?
See, I think jurisprudence or the principles laid down by this judgment, which can lay the foundation for many things, I think are around the what should I say, the further recognition of the voters' right to know. I think that's an important thing, and the voters' right to know extending to political parties, from voters' right to know about candidates now being extended to political parties. There's another angle there which I will discuss, and then the recognition that the voters' right to know trumps the funders' right to privacy. Okay. That's the core of the judgment.
Yes.
These two principles are the core of the judgment. The comments about clean funding and otherwise are really sort of recede into the background, given that the decision revolved around voters' right to know, voters' right to information trumping the funders' right to privacy.
Yes.
Okay, so that's the. There's also some discussion about corporate funding, which we can discuss, and which is an important discussion. About what should corporates fund, how should they fund, limits around corporate funding, can loss-making companies fund, all of those things are asked. Not all of them have been addressed, but all of those questions have been raised. Okay. They did not, see, the court was also discussing these issues only in the context of striking down certain provisions, so that discussed only to that extent. The court did not have any solution, and frankly the court cannot find answers to these questions. That has to be found outside courts. Courts can at best say, if you go and show them a particular scheme, they can say, okay, it's right or wrong. They can't really create a framework for how funding of political parties should take place. That's something we have to figure out. But so on the voters' right to know and the recognition of um, that the fact that the voters' right to know trumps privacy of political parties and candidates and funders. I think that's an important issue. Okay. So ಅದರಿಂದ ಮುಂದೆ ಏನು ನಾವು ಬೇರೆ ಏನು ಹಕ್ಕುಗಳನ್ನ ಹುಡುಕ್ಬೋದು, ಅದ್ರ ಮೇಲೆ ಏನು ಬೇರೆ ಏನು ಕಟ್ಟಬಹುದು ಅನ್ನೋದನ್ನ ನಾವು ಯೋಚನೆ ಮಾಡಬೇಕಾಗುತ್ತೆ. ಬಟ್ ಇಟ್ಸ್ ಅನ್ ಇಂಪಾರ್ಟೆಂಟ್ ಡಿಸಿಷನ್ ಟು ದ ಎಕ್ಸ್ಟೆಂಟ್ ದ್ಯಾಟ್ the voters' right to know is now considered sacrosanct. And surprisingly, until now, it was not considered sacrosanct. Surprisingly. And this is my biggest, actually, one of my biggest grouses with this judgment is, and for lawyers, it's a great judgment to read because there's so much about rights and, the proportionality test. There's 4-pronged test. It's very technical, right? But if you look at it, if the court had started from democracy, right? And why do elections happen? Elections happen because not to create some super state, right? Elections happen because we are electing our representatives to represent us in parliament, right? In the sense that we are the bosses. Okay? If you want to put it lightly, I mean, the people who are the true owners of the country are exercising a right to nominate someone to go and sit there and make policy. That's the process. And that is now being recognized. It didn't have, there was actually debate about voters' right to information, how much of it is valid, whether it's fundamental right, no, etc. There was a lot of ADR na ಮೊದಲನೇ ಕೇಸ್ನಲ್ಲಿ 2002 ಕೇಸ್ನಲ್ಲಿ ಸ್ವಲ್ಪ ರೆಕಗ್ನಿಷನ್ ಬಂತು. ಆಮೇಲೆ ಪಾರ್ಲಿಮೆಂಟ್ ಅದನ್ನ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ನಲ್ಲಿ ಇದನ್ನ ಪಾರ್ಲಿಮೆಂಟ್ ಸ್ವಲ್ಪ ಡೈಲ್ಯೂಟ್ ಮಾಡ್ತು ಒಂದು ಥ್ರೂ ಅನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಟು ದ RP Act. But in the PUCL case and in one more case, the court said no, that is not correct. You should, whatever has been held in the ADR case, in the 2002 ADR case, should be followed. But even during the last parliamentary elections, I remember, the candidates went and got a blanket ban on discussing information about that candidate. Okay, many candidates, but in Bangalore South electoral constituency, for example, one candidate, he went and got a blanket stay about discussion of certain kind of information, even though the election commission said you can't do that. And then we rushed to court and then said, you have to undo this because it's against Supreme Court. And the civil court gave an injunction, right? So then the debate was, is this a fundamental right? Does the voter have a right to know everything? So that was not a guaranteed right. So that's what, if you ask me what is the one thing I'm most happy about in this judgment, it recognizes that the voter's right to information is sacrosanct. I think that actually is the biggest positive to come out of this judgment. Right? The electoral bond scheme going away is an aside, although it was the people think that was a big victory in the judgment, but I think it's an aside. And that's my perspective. There are others who feel it goes, this does actually achieve a lot. But my perspective is that this is the biggest right. And what can we do using this? I think we can do a lot. If you think about it, and it will sort of evolve. Recognition of the voter's right to information is very important, because see, right to vote until now has not been recognized as a fundamental right. Okay, there's a passing reference in one judgment, in one constitutional bench judgment by one judge. I think it was Justice Joseph, if I'm not mistaken. So it's right to vote is not being recognized as a fundamental right. But democracy is considered as part of the basic structure of the Constitution. So this also gives us some, sort of room now to push some other things forward in other cases. So that's a very good thing. So in terms of jurisprudence, I think that's the biggest thing. There's also, some other, purely looking at as a lawyer and on some technical issues, I think the court has gone quite far in terms of manifest arbitrariness, for
Yes.
example. They have recognized that. That's an important thing for many legislations, because now legislations get made like in half an hour. So this is a
Without
very useful.
consensus also.
This is a very useful thing. And whether we can use it in other judgments, I think we will see. But I think people will use. So from a pure lawyer's perspective, manifest arbitrariness is the biggest thing to come out of this, and lawyers will be very happy because it can be used in many cases. From a citizen's perspective, I think the recognition of the voters' right to know, voters' right to information, and that being sacrosanct and should trump the political parties' rights to privacy and the funders' right to privacy. I think that's it.
Thank you for that, sir. My other question is this: of course, all the judges on this bench very emphatically hold that Article 19(1)(a) is violated in this through this electoral bond scheme, and that right to vote is also a part of your freedom of expression. And since that is a right, even where you put your money, that's also like a incidental or like a consequent right under freedom of expression. But now there is this privacy of rich donors, and there's a lot of obscuration there, because and the court of course notices it, that not all their funding can be regarded as freedom of expression, and that some of it is quid pro quo. So if you can talk more about quid pro quo as a concept and how that works in the electoral processes, and one more thing that this judgment notes is that this electoral funding is not limited to the election times or campaigning. It's throughout.
Yeah.
So they're not just using it for elections. How the money is spent is also not very transparent. So they could be spending it for their offices or anything. The politicians there's nothing to really stop them from spending it on whatever they want. So if you could shed some light on this, it would be great, from of course practical experience as well.
See, so political parties' accounts are opaque. Okay, it's I suppose in a very light-hearted fashion, you could say the fact that this current ruling party is going after the opposition parties, you could say in a perverse way, it's increasing transparency of the opposition parties, right? But it's not increasing transparency of how political parties function. Political parties are well-known violators of the Income Tax Act and the RP Act in terms of compliance with, or in terms of accurate compliance with both the statutes. That's one thing, right? So that's the reality. But the second point also is, even if they produce their accounts, I mean, I think there's a lot of things that happens outside the balance sheet. Okay, because that's how political party funding works. So there is we haven't been able to figure out a way to measure this. Okay, so we don't know, and all ideas are welcome kind of thing. Situation exists even today. So your point that the court did talk about, this is not just funding for elections, it is funding for political parties, is right. Because if political parties are building large organizations, they need money.
Yes.
Okay, otherwise what happens is every player within the political party operates as an independent agent. So he raises his own source of funds, he then becomes a sort of god to himself, even within that political party. And that you see that, and that's why there is so much jumping of candidates. They don't really care about a political party or the political party. They'll go to whichever political party is about to get come to power, and then there are many of these players, and those players are there in most states. That's one thing. Now, two, what is the, when you're commenting on, rich donors or otherwise, and whether this leads to your earlier question, which I didn't deal with fully, is like one person, one vote, and whether there's inequality because of electoral funding, and whether the 19.1a angle and 19.2 angle,
Yes.
Because one of the grounds that they discussed here was that this does not fall, the electoral scheme, the electoral bond scheme does not fully fall within 19.2,
Yes.
because what the government said and what it argued, so when the government, when it passing the electoral bond scheme, said it is to curb black money,
Yes.
but the Solicitor General argued this is also, there is also the right to privacy of the donors. On black money, the court said this is not curbing of black money is not something that finds a place in 19.2. Okay.
Public interest.
Public
yes,
interest,
it's
but not
yeah.
And then it also said, interestingly, this is not the best, necessarily the best method to curb
Correct.
black money. I mean, you could even go through electoral trusts. Okay, and that is another thing they said. So then, after having quickly sort of decided on that issue, then they moved to discussion on the privacy of rich donors and all that. And this is where I find, I think if you look at it very carefully, I think this is where there is a difficulty in my view, because the court has gone to great lengths to discuss the right to privacy, and they recognize that people who are giving money have some right to privacy because of the Kutuswamy judgment. But they say in this case, because the right to voters, right of the voters to know about political parties is more sacrosanct, it trumps over the right to privacy. Okay. Now, if you just take these three things, there are many issues, nuances I feel here which could come back to bite in future cases. Because the court recognizes the court sort of, tried to trace the right to vote into 19.1a as a form of expression, I think these problems arise. But is right to vote really a form of expression? I mean, the right to vote, I think, is far, in my view, goes beyond 19. Okay, it's part of, we are behind the Constitution, right? We set up the Constitution, and we have set up this methodology of governing or administering ourselves, right? And the right to vote is not only, in my view, something that finds place in 19.1a. So, and I think that is, in fact, according to me, and even if you look at it from a constitutional law scholar perspective, that I think is an extremely limiting factor. But as I said, that we should not complain too much about this, because the court decided what was argued before it, and the petitioner's arguments, went around this. I feel that a stronger argument would have been around democracy, right? And the right to vote is an integral part of democracy, and it may not have been written in the Constitution, but hey, nobody wrote the basic structure in the Constitution, right? So this, I think, once you recognize that democracy is the core of the Constitution, you can't say right to vote is a form of expression. I think it's extremely limiting for the right to vote. Okay? And that's where my worry is, because the court has gone to a great length to do this proportionality test and all that. And then you realize that even if at one stage it is a better scheme, and if you lose on one of those tests, of whether the necessity test, rational connection test, the four-pronged test, and then they bring in some other test from, an English judgment and an Australian judgment, and figure out all this, I feel it is limiting in a way, and that's my worry, for the future. While I'm happy about certain things, I think that's my worry. I think a better, a sounder footing would have been in democracy, but the court was not dealing with it. So because nobody argued it, so I don't think we should um, spend too much time worrying about it. But because you asked the question about whether it is a form of expression, I think that's where the lacunae comes through. I mean, how can you say right to vote is a form of expression?
Right.
It is not. Right to vote is who we are. I mean, for democracy, right? I mean, it's something that we should do. It's part of the basic um, uh, tenets of how we are structured as a country, right? And if you limit that in terms of 19(1)(a), and then you are subjecting yourself to 19(2), then there are problems, and problems could arise in the future, but we can deal with that at a future stage. The second point you asked about is does this add to this right to this one vote one person? I don't think. In fact, I feel even now I think it's only during elections that one person one vote truly works in this country.
Right.
That's actually the only place, because votes are counted, right? And it has to stack up. Right? It has to stack up more than the other person, more than the next candidate. So I think that's the only place where it counts. So I don't think it sort of adds to the principle or reduces the principle, because the challenge of money remains. And if you're influencing, if money is influencing elections, I think that remains irrespective of electoral bonds.
Thank you for that, sir. One more thing is there was a recent news report by TNM and News Laundry about this trend where the there are some companies that were donating were previously noted to have IT or ED raids on them. So basically, it enabled the government to extort money and loss-making companies, for example. So corporate funding itself, how does it work today? And of course, it has a lot of influence. But this kind of whether it's not in the US, there's of course this revolving door politics where corporates have a lot of lobbying influence on the government. But here it seems more than lobbying, the government is extorting, right? And it has given itself the powers to extort through these EBS system. So if you could if you want to comment on that.
See, I think you're saying they've given themselves the power to extort. I think that's not given in any law. I think that's they have the power to extort because they're in power,
Yes.
because they're ruling, and I think that is there. That exists irrespective of the electoral bond scheme, but that happens because we have a weak sort of enforcement mechanism, right? We have a weak rule of law, and that's the reason why the people in power are able to do this. Okay, so that's a sort of a more sort of deeper question that you have asked. But if we look at, and I'm not surprised at the news reports at all. You can even look at, many people joining the ruling party today, I mean, from opposition parties, are all people who have been facing some sort of charges or the other. So that's also another form of, sort of, aggregating or expanding their own political sort of base, right? I mean, you're threatening the opposition leader, and then after a few months he joins, and in the case those cases go away automatically. So this is very clear what's happening, and it's evident. And so this is, I'm not surprised that cases and raids, etc., have led to more funding to one political party. I'm not surprised, because ultimately the people who are facing the cases want to get on with it. They want to solve their problems. So is it extortion? Undoubtedly, yes. And that is the point that I made earlier also. So how do you prevent this extortion? I don't think the scrapping of the electoral bond scheme will necessarily stop that. Okay, so maybe it was just a method of extortion. They'll figure out some other method. Okay, and that is a larger point that we have to discuss. Um, the electoral bond scheme was just a convenient method of doing it. Um, and in a way, I was talking to somebody who said that, listen, isn't it better that it changed, from cash to electoral bonds? I don't know whether it's better. I mean, do we need so much cash in the system? We don't. But is this a better mechanism? It's clearly not, because there is so much. See, ultimately, what is the usage of cash? Okay, usage of cash is ultimately cash doesn't come from somebody's pocket. Right? It is in the system. It is money. It is legal tender. So it's just not accounted. And because electoral bonds also told the political parties you don't have to account for it, you don't have to show it in your accounts, you don't have to disclose it in the form of under the RP Act and under the Income Tax Act, and companies also got an exemption in terms of compliance. So I think it became a sort of a sheltered scheme.
Yes.
So there is no difference between the two in my view. The only difference is that this is money that people have paid income tax on, whereas cash technically is outside the income tax net. I think that's the only sort of technical difference, because companies who are giving money through banking channels to buy an electoral bond. If you go to, if you went to SBI and bought an electoral bond, presumably, I haven't bought any electoral bond, but presumably you transferred from one account to SBI. You didn't take like 1 crore of cash and said, give me electoral bond, because SBI cannot accept that much cash. They can only accept 20,000 rupees, and above that it has to come from another bank account. So that is the only advantage. So presumably it was all accounted for money, whereas cash is unaccounted for. It doesn't find any place in any books of accounts. So that's the only difference. Now, you asked the right question about, so how do we sort this funding out? See, many people have suggested many things over the years, including state funding for political parties based on percentage of votes garnered and all of that. I don't know the answer, to be honest, and I think this is something all of us are grappling with, not just here but in every other country. Maybe the way forward is through electoral trust, and the scheme did come through, but it was the electoral trust scheme as it currently stands is very, very narrow, and it doesn't allow, for example, say people like us to just start an electoral trust and say, okay, let everybody who wants to give money to political parties or to candidates, say people who will say, I will fight on certain policies, certain principle, and I believe in clean politics. I won't take cash. I won't take bribes, and to insulate the legislator or to insulate our representative from the pressures of funding. Okay, so if we are able to create an electoral trust mechanism where the electoral trust funds the candidate, electoral trust sort of collects the money and it funds the candidate without the candidate knowing who are the donors. Okay, that's one way of doing it. But there you need two kind of commitment, or rather 3 levels of commitment. One, from people who are donating to the electoral trust, they have to trust the people who are managing the electoral trust not to do things which are sort of untoward. That's one point. And they should not expect any favors from the person elected or who gets the funding through them. That is the biggest challenge. So if you have to fund anyone today, whether a party or a candidate, are you willing to do it without expecting anything in return? Not direct with pro quo, but even in influence. Okay? Or will you be upset if that if that party or person who is in power then takes a decision that goes against you, even though you have funded that person? I think that is the question. And I'm actually taking it to the extreme, but it's not going against you. If it does not do things that favor you positively, that's even more of a thing. So you are giving money, saying, okay, here's like whatever, 10 crores, 1 rupee, 2 rupees, 20 crores, whatever it is. Are you willing to say, okay, you know, here's 20, I have 20 rupees, I'll give 20 rupees, you go and contest, that's it, I have nothing to do with you anymore. I'm just giving you 20 rupees. That kind of selfless funding is what we need to figure out. So, I'm glad all of you are laughing, saying who's this idiot who's talking about selfless funding. But that is a problem, and that doesn't happen. So it's not just rich donors. Okay, let's also see, when we're talking about rich donors, in a way, what about people who take, you know,
5,000
two pressure
rupees,
cookers or whatever, right? I mean,
alcohol.
so, but that's a different kind of way. They're not really funding, but that's where the money is being spent, I'm told, but
Yeah.
we don't know. Because if you see the wealth of the people contesting elections increasing over the years, I mean, it shows that it's not all about, you know, just distributing free cash. It's also about
We get something back.
aggregating, you know, wealth for themselves and their families. So that's the, so I don't think it's a question of rich donors or otherwise, because we have not figured out a method of insulating the donor and the people who contest elections and win elections from each other's influence. Okay, that's the problem. That's where it lies, right? So is a donor happy to give money and then say, I will accept whatever you do? They are not. And can we find such kind of people? It's very difficult. Similarly, are people who are elected on the basis of support, economic support from individuals, are they able to say no to those chaps, to the people who have funded them, saying that, listen, I will not do this because this is not, you know, according to the law, according to principles, or according to whatever, right? According to propriety, I don't know. So I think, so it's also about people and process. And on both counts, I think we are struggling. Right? Process we have not been able to figure out, but process also is dependent on the people. And this is true. I think it appears, at least from whatever we read, I think this seems to be a challenge in most democracies. Right? Different people have found different methodologies of electoral funding, but I was reading somewhere, you know, about 10 years ago, about how the Democratic Party in the US was so happy that apparently some, you know, tech billionaire just sent them, you know, a check for, you know, so many millions. And then and when they called him and said, can we come and meet you? He said, no, I don't want to meet you. I just want to give you the money and that's it. Don't talk to me. And apparently he never came. And he never came and met them. Nothing. He just sent a check and that's it. So are we able to find, you know, people like that? I think it's very difficult. So unless we find those kind of people, and also find candidates who are happy to say, listen, I won't do this, and if it means I won't get money from you next time, then so be it. And if I lose, so be it. That also doesn't exist, because politics has also become a profession, right? It's not anymore just some romantic, you know, method of representing people. It's a full-time job, and that is a question political parties also grapple with. If it's a full-time job, if being an MLA or an MP is a full-time job, and an MLA or an MP has to live on the salary that he gets, how do we ensure that that person also, you know, has the same level playing field as somebody who is a, you know, a lawyer or a businessman or whatever? And should they sort of have a level playing field? We don't know. You see, these are all questions that we have to find answers as we go along. They're difficult questions. They're not easy.
So my last question is, I mean, I think this is a very important point made, like argument made by I think senior advocate Kapil Sibal. It was on this presumption of constitutionality, and I think it relates to what you said about like right to vote goes beyond like fundamental rights also. So he talks about, this argument was that usually laws made by the parliament have a presumption of constitutionality. They are assumed to be constitutional. unconstitutional. But when these laws change something as fundamental as like the electoral process itself, you can't like give it you can't presume the constitutionality. You shouldn't be. So that's what he argued, and the Supreme Court didn't really delve much into it. But I think that argument, provided how the laws are being made today, like does the parliament today really represent the will of the people? Because the presumption of constitutionality comes from assuming that the parliament represents the will of the people, and that's why what they do has to be presumed to be constitutional. So now when those things are changing today, and this argument can be built upon is what I feel, to like take us back to like protecting like our basic structure, at least like when the parliament tries to like sort of meddle with it. How do we like, and especially the will of the parliament is like not really like, because you know how the parliament is formed itself is not very right, and they're not functioning in a way that it represents the will of the people. So how do we sort of like develop that argument to use it? Because there are many laws right now coming into force which are like not really deliberated upon properly. So I was just thinking whether we can use that or develop that point further.
See, I feel it's a difficult proposition. I think what the argument that was made was in law, when you're dealing with constitutionality, when you're dealing with the question of constitutionality of laws that deal with the electoral process, the lawyers arguing for the petitioner said, don't presume constitutionality, because the court presumes constitutionality in all legislations, right? And the burden is on whoever challenges the legislation to prima facie show that there is a problem, and then the burden shifts, right? The court said no, and I feel rightly so, okay, because see, now the problems of process should not affect the legitimacy of an institution, okay, and that is something we should, well, it sounds exciting to say, okay, if Parliament has not debated a particular law, then that should be reason for saying don't presume it's constitutional. Okay, I think that doesn't work in my view. I mean, I was thinking about it, and actually, in the state legislatures are worse. Like if you study the functioning of state legislatures, they sometimes about 70 bills are passed like in 2 minutes. Nobody even sees it. And these are all important legislation, like increasing stamp duty, increasing property tax rates. All these are important legislations, and they're not discussed; they're just passed. Now, whether the outcome would have been different if there was debate, also we don't know. Maybe it would have remained the same. What I hear from many parliamentarians is many of the discussions happen outside the House, in joint parliamentary committees, in other committees and all. Now that's not an excuse, because they have to debate in the House, and that's their job, right? And they're not doing their job. But whether it should lead to a presumption of, or whether it should lead to a no presumption, okay, situation rather than a presumption situation, I don't know. I haven't really given this too much thought, but I feel it's not I don't think it's a great principle. I think it's a bit of a dangerous principle, right? Because then, because everything that you do is, whatever said and done, right? You are influencing, because of money power, how people vote is influenced. All of that is true, but at the end of the day, see, when you go and press that button or tick the ballot paper, you're doing it. I mean, you can argue about free choice, whether you're really free, whether you're in the influence of something, and all of that. And this is a question, I'm digressing a bit, this is a question I have pondered many times. How do you, when you're voting for a particular candidate, are you forgetting what that chap has done? We do. I think we forget. Like I remember the first time we did At Daksh, we did a sort of survey to see which MLAs were more popular and all of that in their own constituencies. And after that, the survey results came, and before we sort of published it, we debated whether we should continue that, because the guy who topped the charts was facing 2 murder charges and was in jail, right? And we said, look, should we do this and sort of contribute to this person's popularity, right? And that's when we need to realize that, listen, people are actually going and voting for this person, and we have to assume that people are not idiots. Or people are not fools, or people are voting in their best interest. Because I think if we think that people are not voting in their best interest, then all of democracy is in question. So I think we have to assume people are voting in their best interest, and we have to assume people are doing the right thing. Okay, whether they are doing the right thing in a way, or whether they're able to check their representatives from doing the wrong thing, that's a separate issue. And that's a process issue, and we haven't figured out a process, for example, of holding MLAs and MPs accountable. We haven't figured it out, though they are accountable only during elections. Right? So there's no intermediate process. During the 5 years, there's nothing. Right? It depends on the MLA, and it depends on the constituents. The interaction can be zero, interaction can be very, very robust. They may do a lot of work, they may not do a lot of work. Also, we are moving towards an executive MLA MP situation, which is also dangerous. That's a separate thing, maybe for another discussion. But what I'm saying is, so if you start questioning every law that Parliament or legislature makes on the ground that this affects this is not a good law because it was not discussed, that is not, I believe, a good way to go. But I think the argument was there was one more nuance to the argument which is probably worth exploring, which is, if it relates to the rights of the legislatures themselves, should there be a presumption? I think that is really the argument they were trying to push. Because this relates to electoral democracy, which ultimately decides on the manner in which the legislators and parliament is elected. Therefore, don't presume constitutionality on this. But then, if you open that door, then where will you stop? But that, I think, there is a path for a good legal argument there because of conflict of interest.
Yes.
See, you have education ministers who run educational institutions, right? You have industries ministers who have large industries. I mean, about 3 years ago, I remember reading a news report saying that in the Global Investors Conference, the biggest person who had announced a project was the minister's company, saying that we are going to set up a new factory of whatever, costing so many millions of rupees, and the industries minister was announcing it. It was his own factory. So what is the enormous amount of conflict of interest among ministers and among individual MLAs when they are debating these legislations? That is a bigger cause of worry. And if the petitioner's arguments was based on that, then there is something to be said there. Okay, but then you would have to do a statistical analysis of 544 MPs and see how many of them had a conflict of interest in this, and therefore don't presume constitutionality. It's a challenge. But there is something there. Okay, if you are, for example, I mean, the most obvious thing is when they increase their salaries and perks and benefits and all of that. That's the most thing. If somebody is challenging that legislation, then maybe you can argue saying that don't presume constitutionality of that legislation. But other things, it's difficult. So you have to presume, because if you say that anything passed by parliament don't presume constitutionality, then you're challenging the very election. Right? You're challenging democracy itself. So it's a bit dangerous, I feel. And we have to sort of rein ourselves in from making that argument. But the nuance around this one, around conflict of interest. And I think that's what they were trying to push,
Yeah,
but
they
it's
were.
not captured very well. I think there's some argument there, but lack of debate in parliament, I think, is very difficult. You may not be allowed to open your mouth. And even forget about opposition party. Even ruling party MLAs don't know what legislation is being presented that morning. They sent a note, and it's not just this government, okay, not just the current government in the center, but look at the last 40 years. I think that's the story. So I don't think, these guys have taken it to a new level, but the last 40 years is the same story.
So we can open up the floor for questions from all of you all. So hi.
Yeah, I have a couple of questions. First, about the judgment itself. Supreme Court pretty much categorically said that it's patently unconstitutional. Now, can there be any sort of mechanism? Is it naive to think that something so unconstitutional was allowed to exist for so many years? What kind of mechanism can prevent that to happen?
Meaning the time taken
The
for
time,
declaring
yeah.
it unconstitutional.
Yeah, so if they knew that it's unconstitutional and it was allowed to function, and it has wrecked democracy. So now, is there nobody that could be held accountable for allowing this to happen for so long? Apart from whatever the judicial mechanisms are that exist, is there something outside that where possibly some workable mechanism can be? Is there? Could we even look somewhere?
No, I don't think we can look somewhere, because whatever we create will suffer from the same infirmities. Right? If we are looking at something, that's what people said, it's India against corruption, all these guys fought for Lokpal. That's also, we have had Lokayukta here, and it's varied from the person who occupies. It becomes a good institution when the person who occupies does something. Otherwise, see, we have to trust the institutions we have created. There are challenges with institutions. Your question is, why did it take such a long time for the judiciary to declare this unconstitutional? I agree with you. I've been working on with judicial delays for the last 6-7 years, and it's a challenge. Many of us have dealt with cases. I don't know how many lawyers in this room, but all the lawyers deal with cases which don't see closure during our lifetime. Right? So that's a challenge, and that's a problem with the judicial system we need to tackle. Right? And I agree with you. It should have been heard on priority and decided quickly. But priority, why? Why should this be given priority? It should be like first in, first out. What happens to the case which has been filed, in 2001 and still pending? Right? If priority is given to this, and you could say this is more important. Those are all difficult questions. So we need to improve how the judiciary functions, and without that, we cannot have a more robust answer. If you ask me, this has happened fairly quickly. In 6 years, we have got a decision. Right? There are many other things that are pending, which is not, which haven't seen the light of the day. But I'm with you. This needs to be decided. Something like this, they should have heard it immediately, right, and decided within 6 months. So there is no. And the second question is actually more interesting, in the sense that the courts have unfortunately in this country always been reluctant to undo the damage that an unconstitutional law has done. Okay? And they always, even when they overrule it, they say, okay, I'm finding everything that has happened in the last 5 years illegal, but unfortunately we can't do anything about it. So you can't do anything from tomorrow. But whatever has happened has happened. I remember, in one case that I was appointed as an amicus in some matter where, and again, just to tell you the starkness of the problem that we are facing, where both the petitioner and the petitioner's lawyer had died. Okay, in a PIL. So they wanted somebody to, push the case. So I looked at it, everything, and then I made the arguments. Then what had happened there was an entire, a large piece of land had been allotted illegally. And for 20 years, nothing had happened in the PIL. So the court found the allotment illegal. But in 20 years, many people have bought and sold properties there. So I said, we can't do anything about it. So it was a waste of my time, it was a waste of the court's time. But that is how courts have been in this country, not just in constitutional cases, but in every case, this is what happens. Right? Unless you get an interim order first thing, which says that don't do anything at all under this statute, and in constitutionality challenges, they don't do it, unfortunately, because there's a presumption of constitutionality, which Murtala pointed out. They don't say, don't do anything. In some cases, they say, or the government itself says, okay, we won't do anything until you decide. In another case that we have, another PL that we filed, they said, okay, announce the fact that this case is going on and any effect will be subject to this court. There are ways and methods of doing it, but if your question was, can we create some other alternate mechanism, I don't think there's any other alternative. We should have better MPs.
I guess a related question that comes to mind, and it's not necessarily a question for you to answer, is just that, I mean, one way, of course, of dealing with this is this kind of retrospective judicial review, right, of laws that we would say are looking like they might be unconstitutional or through a petition or something, but like one wonders if some kind of a more robust process should happen, like at the time of passing those laws. I mean, we have some parliamentary committees that get formed sometimes. We also understand how laws are being passed at the moment with just like a very 5-minute process. But yeah, I guess that becomes the other question that comes sometimes, I guess, bothers us, I suppose, that at the time of passing of the law, with everything in mind about what you said, that no, we have to presume that the parliament is going to look at people, what can be done, or how can we envision that process being a little bit more robust, maybe?
See, one of the things that many of us were arguing was, we were arguing for scrapping of the 10th schedule. Okay? And we were saying that makes MPs more independent. And we said, okay, don't, or maybe keep it only for, say, the finance bill and, no confidence motions, because we don't want horse trading at every time. But, allowing MPs and MLAs to vote as per their conscience or as per the wishes of their constituents on most legislations, we feel would make a difference to the debate also. Because then MLAs will actually speak. Today they don't speak, they're saying, what's the difference? And I have interviewed many MLAs to ask, okay, why don't you speak more? And what difference does it make? If the TV, if it's being telecast live, then maybe some people will say, oh, he spoke very well. But if we are discussing about legislation, it makes no difference. Okay, anyway, it will get passed because there's a whip most of the time. And you have to vote only in a particular fashion. You can't, even if you don't agree with something, you have to vote in that favor because your political leadership, your party leadership says that. So many of us actually have been arguing that the 10th schedule should be done away with, except for maybe limited things like no confidence motions and and whatever leads to instability in the government, like finance bill. If the government loses the finance bill, then that's pretty much like a no confidence motion, right? So except 2 or 3 things, we said for everything else you should allow the legislature to vote how they want, but parties won't agree to that. And that's where my second complaint with this judgment is, while it recognizes the political party, this is the second time this is happening. Otherwise, political parties actually are not mentioned in the constitution. Like, there's no reference to political, except when the 10th schedule was brought in, which is when the concept of political party came in. And now this judgment actually sort of legitimizes that a little bit more. So the challenge to the 10th schedule has become more difficult in my view from now on. But that's one way of looking at it. That's how we have to, strangely as this may sound, we have to empower MLAs. I know we said, they're very powerful to extort and all that, but within the parliament, within the legislature, MLAs and MPs, unless they are in power, unless they are a minister, they are struggling. They are, in a way, also, many of them are disenfranchised within the parliament. They have no say on the vote. That's the point.
But in a way, they like it that way. In a way, they like it that way because they
Yes
want
and
to
no.
challenge the
Yes.
establishment in that sense and their party position.
That's correct.
Maybe the next time I will get a higher rank. Maybe
Yes.
the next time I will be promoted
Yes.
because I'm so good.
Yes. But what that has also happened is it sort of concentrated powers in the hands of a few and across political parties. And we are seeing a sort of an extreme form also in the current central government. But that's true of most state governments also, where the chief minister is so powerful that nobody else really has a say. So that is also a challenge. And many MLAs have complained that we don't even know what's happening. They won't even know which bills are coming the following day. So they have very little say in some of these things. In some things they have a say, but in some of these things they have very little say. So it's a difficult proposition.
Another question. We are talking of constitutionality in an unconstitutional state and in unconstitutional proceedings. But in this context, I just want to ask you whether when there is this whole issue of electoral bonds, this is basically about the money that has come in as a bond to political parties. No? Is there anything whereby, I don't know about I've not read the judgment or anything, but is there anything whereby there is some thing about audits on expenditure from these bonds? Was there any way of controlling that, not just the money that has come in, but also the question of how it is being utilized and where it is being utilized? Because we are clearly seeing how the PM Cares Fund anyway cannot be audited. So was there anything within this whole thing about the electoral bonds money coming in, and therefore it could be audited and it could be, understood, any form of transparency in that sense?
No, transparency after it reaches the hands of a political party.
No, there was nothing in that.
Disclose the audit. They have to
No.
disclose the audit, but that is not compulsory.
See, but that's
Within
been
like society
that's a
where
provision.
forbidden audit.
That's a provision that's always been there, and the election commission is actually entitled to cancel the registration of a political party if the audit is not done properly and not submitted properly. But most they will go after some small political party which is irrelevant if they don't
It starts
submit.
from Srinivas Malak.
Yeah, but it won't. They won't. None of the large political parties, I think, were submitting. But again, there's an ADR report a few years back about this, as to how many political parties have consistently audited themselves and given the report and all that. But the election commission has the power to do it, but
The next question was about the election commission. Like, what is the role even in this judgment related to the electoral bonds before it was declared null and void? But what is the role of the election commission in this, in the sense of accepting that this be there, the judgment be valid and be continued, or putting a stop somewhere? What can be the role of the election commission? Because this is an electoral process, a part of the electoral process.
see, they can't make law on funding of parties. Right? Election commission can't make the law on fund. That's up to parliament. So they don't really have a role in the electoral bonds mechanism, except for insisting on the returns being submitted by the political parties and monitoring that. That's the only thing they can do. Otherwise, they don't really have any role.
Processes
The
of
only
representation, processes of...
no. The only other place where they have a role is in checking expenditure during elections. That is in that 15-day period only. In fact, they don't even have a say if a candidate or a political party spends a lot before that period of official campaigning. They don't really monitor that. So it doesn't really. So, and the second, another point about the election commission is it's a very, very thin body. It does not have an enormous amount of personnel. For example, in Karnataka, if you go to the state election commission's office, he or she is an officer that has been seconded by the state. And during elections, they mobilize the entire state machinery to conduct the elections and to monitor. And after that, the officers are directed by the state. So the enforcement mechanism is not completely within the EC's control. So maybe that is something we can strengthen. Give the EC the full power to prosecute and make it meaningful by giving personnel and enough authority. I think that is the issue. But is it something that they want? Because actually it's the job of the police and the others who are supposed to do it. See, you have weak mechanisms around to monitor all of these things. And monitoring only one particular thing, it's not going to help. And the monitoring is zero in all of these.
Is the
Election
money
completes
going to?
all
I'm sorry.
From the same question, in this particular case, were the views of the election commission sought or anything in the whether party?
You know, I mean, the election commission won't have a view. They're not supposed to. Why should they have a view? See, they don't have a view. I think what they have done now is they have said, okay, you have to disclose details of the bonds over the last 5 years and publish it and all of that. I think it will be interesting to see how the government complies with it and how SBI complies with it. But apart from that, the election commission cannot have a view on this because this is a law. It's not a rule that is being made. It's not a scheme that was created by the commission. It's a scheme that was created by the government against the wishes of the RBI, which was the only authority which could have said something about it. The RBI opposed it, but the government went ahead nevertheless and amended the RBI Act also. Okay, to give power to the scheduled banks to issue this bond, because RBI took the objection that only the RBI can do it, no other entity can do it. But the government said no. So clearly, they didn't want any sort of interference.
They were also silenced. The RBI also was silenced.
No, not a question of silence. I mean, if see, ultimately Parliament has the power to amend the law.
Yeah.
It's as simple as that. So it was amended.
The money that is coming from encashing the electoral bonds, does it go to one source? In a sense, is this a question of decentralization within the political parties itself? Like, can Yediyurappa get the electoral bonds encashed in Bangalore and central government gets the electoral bonds encashed in Delhi? Or is it, don't state leaders have a question, bone to pick with the whole concept of electoral bonds?
See, I think from what I understand, this is for the party.
Right. But within the
Bond
party,
is-
will it be one account?
The
or-
bond it is one account. No, you can't have multiple accounts.
Yeah, so that means it's going to concentrate
See,
the
and
party.
that is the thing, right? Because it was so opaque. Because they said the disclosure of the political parties excluded the electoral bonds. Whereas earlier they had to disclose everything and account for everything about 20,000 rupees. But for electoral bonds, that was not there, and that is a problem. So how it is being used, whether it was being used by an individual, by the party, whether it went to the accounts of the party, all that is also not very clear. Because once you redeem, and the only way, because you couldn't redeem it except for it going into an account. Now whether it went, and because it's for a political party, I think it could only go to a political party's account, not to a candidate's account or an individual's account.
Yeah.
But we will know now when the details come. Nobody
When they
knows
have
it,
to.
right? That's the problem. No, but I think the assumption is that it goes to political parties and that there is no other method of doing it.
And even within political parties, it will be one source.
Whether it went to different. See, the point that you are asking is whether this is diversification of power within the political parties. No, I think it was to centralize the whole thing, right? The whole point is to control them. And on that issue, I don't think the leaders of any political party will disagree. They're all on the same page. They don't want too many players becoming independent and strong. So that is the challenge.
Accountability towards political party, there is no such mechanism in India as in respect of funding or utilizing of funds. Only the mechanism towards the candidate who planted very hard. They have to submit their accounts. Party cannot.
No, so there are two things. What a political party spends during an election is different from what a candidate spends. So the the limits, the electoral spending limits that are announced is on the candidate. What the party spends is not accounted to the candidate. So the party can spend a lot, and that's where Mridula's question about equality of votes. The inequality comes from a rich political party spending a lot of money as against an independent candidate. So both the candidates can only spend 45 lakhs if it's an MLA election, or 75, 80 lakhs or 1 crore if it's a parliamentary election. Or all candidates can only spend that much. But what is accounted to the candidate does not include the money spent by the political party. Okay, and that's why political parties also go to great extent. So if there's a rally which the 10 leaders or the national level leaders are attending, then they make sure the candidate doesn't sit on the dais. So if he sits on the dais, the entire expense of that thing will come to his account, and that wipes out the one expenditure. So political parties spend a lot of money on that. He is absolutely right. Political parties don't need to give expenditure analysis during the election. That only candidates do. But what political parties are supposed to do are file annual returns every year, and that is what's supposed to come. Okay, and not only annual returns to the electoral, to the election commission, but they also need to file income tax return. So Congress is facing some trouble, but I think they would not have faced trouble if they were in the in government.
Submitting a balance.
So that is the issue. Yeah, but even that they don't submit. That's the problem. They're not submitting even that.
But this judgment extends that principle, like information disclosure by candidates to political parties, right? Like,
No, it doesn't. Not during the conduct of elections.
Okay.
What they're saying as a right, voters have the right to know who is funding political.
okay,
That is what they say, but not the mechanics of disclosure during election. That
right,
is not
how much they are spending other. Okay.
that Adhmana Kala.
It's only the way to find out, corporates those who find out, to price catch the power through their parties.
ಯಾರು ಎಷ್ಟು ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಗೊತ್ತಾಗಬೇಕು.
ಅಷ್ಟೇ.
ಅದನ್ನ ಬಿಟ್ಟರೆ ಏನಿಲ್ಲ.
A simple example they have taken. The company which is having it's around 2 lakhs or 25 lakhs of income, but they have given a bond to the one particular party. It's around 25 crore. But the entire profit of the company is 25 lakhs.
That is also a case of just setting it
That
up.
is
It's
part
a
of
case
the-
of money laundering. Yes. It's a clear case of money laundering.
The right to vote question, I think it's interesting that you pointed out to as being maybe one of the key takeaways of this judgment. The other interesting point I thought you made is why do we think of the right to the right to vote and the transparency around that has been located only in 1918. And it's a broader question, personal democracy, and can be rooted maybe in other parts of the constitution. That is a very interesting point. Because thinking about it, see the privacy judgment, again, it's very interesting that they root the privacy judgment in both in 21 and in other fundamental rights. But I think the difficulty you face over here is of course the citizen question. That 19(1) is the one provision which links to citizens. You can't potentially locate it in both 19 and in other provisions as well, particularly around the right to vote and the entire question transparency around that. So I was wondering whether you had any thoughts on where it located. That's one question. The other one is I was wondering whether, since Daksh also involved in the entire question of proposing long-term changes, etc., is there a way in which later constitutions have a better sense of how to deal with the entire question of elections, and right to vote? Other than South African constitution, and what they have is a Part 9 institutions, which include election commission, human rights commission, etc., giving them all a constitutional status. And in a sense, it's a strange thing. The Supreme Court shouldn't be dealing with all of this. The election commission should be the empowered body to deal with all of this. It should be all, right from the election of Chandigarh, goes right out to the Supreme Court. The election commission should be dealing with it. So how do you create a system where all powers are centralized in the Supreme Court? You have a way that's diversified a little bit more. So other institutions take up the task of running Indian democracy as compared to saying Supreme Court has to do the in this case.
The first question, I think voters' right to information, I think should be I agree with you. I think it probably needs to be in 19. I think anywhere else will be difficult. Voters' right to information.
Needs to be in.
In 19, in Article 19, probably in 19(1)(a). The challenge with that is the way we have, so that it's a long-winded thought, so just bear with me, right? So but my problem is the right to vote itself. Where is the right to vote located? My problem is with saying that the right to vote is a form of freedom of expression. I think it's fundamentally wrong, is my view. Because it is not we're not expressing ourselves. It's who we are. I mean, I think, if we are calling ourselves a democracy, then okay, we accepted adult suffrage, then I have a right to vote. Nobody should be able to take that away. Okay? Nobody can take away my right to vote. Okay? Once I am, a citizen of this country and I am here, nobody can take that away. So to say that is a form of expression and then it is subject to the limitations of 19(2), I think that's a problem. So the right to vote cannot be subject to the limitations of any of 19(2) and so on and so on. I think that is the danger that I foresee in the future. But information, I am with you. I think information cannot be elevated to some extraordinary level and then say, I need to know where the MP lives, minister lives, what he is doing 24 hours. Because we are also going crazy now, right? Because if there is ability to, I think there was a petition somebody had filed recently, I think, tag, we need to know where the minister is all 24 hours. We are losing it a little bit, right? But that, I think, is a broader debate on privacy, but that's a separate thing. So the only point I was making was the right to vote I don't think should be found in 19. Information, I agree. I think it has to be, because now we have, after Puttaswamy in particular, privacy is a serious factor, right? And I remember somebody, when this judgment was being declared, I was sitting with another lawyer and he said, no, doesn't this affect the secrecy of voting? Isn't it equal to saying disclose who you want to vote for? Okay, so I agree that that should not happen ever, right? But I think the debate around funders, how much should funders be disclosed, that will go on, I feel, and I think this has opened the road for disclosure around that, and that's why I said if you have gone into such sort of excruciating tests, to determine whether you should know how political parties are funded, I think that there is a danger there, because any of those tests could go either way in the next round of analysis, right? So all you have to do is come up with a better scheme. But if you found the entire principle of political parties being funded as something that needs to be transparent because it's linked to democracy, I think then you need not be restricted by 19(2) is what I think. And we need to discuss this maybe a bit more and understand what it means. Maybe there's more danger, I don't know. But when I was looking at it, even I think last week when I was discussing this with somebody else, I thought that somehow bringing it within the frame of Article 19 may not be great as far as the right to vote is concerned. It should instead be in democracy and not 19. I think that's what.
Mostly it is not considered, it is only recognized under 19(1)(a) for this purpose because it is not spelled out anywhere.
Yeah, and that is a problem in my view. Right to vote being recognized in 19(1) is 19(1)(a) is not a great thing. Recognizing the voters' right to information under 19(1)(a), I agree with. Okay, there is no problem with that. But right to vote itself under 19(1)(a) is a challenge.
Since it is
very, it's not a freedom of expression. Voting is not a freedom of expression. Okay.
choice of their.
Yeah, it's something else. It's something more fundamental. Right? So, and that is very clear. But I think, to be fair to the court, that was not argued at all, because the challenge was something else, and whatever was necessary for the challenge was argued. But this has not been argued anyway. The second point, this concentration of power, I agree, but I'm fully with you. I think the Supreme Court should not be dealing with. The Chandigarh election, but I think actually the Chandigarh mayor election is a failure of the High Court. Not anybody else. which body should deal with it? I think funding probably should be dealt with by now by some other body. I mean, whether it should be the election commission or somebody else, we don't know. But funding of political parties is the big elephant in the room, and because it is skewed electoral democracy completely. It is skewed electoral democracy in favor of people who can accumulate enormous amounts of money quickly and not necessarily through legal means. I think that's the those are the guys who are in play, right? Not even people who earn money legally, properly, are not necessarily wanted in that space, right? So they want people who can accumulate enormous amounts of money in a short period of time in all forms possible. I think that's what it's become. Electoral democracy has become, right? So we need to look at funding and electoral funding in particular, and we need somebody to examine that and examine questions around that issue. I think we need. But the Supreme Court becoming sort of the center of all these powers, I think there are other questions at play. I think partly because the Supreme Court, in a way, and while they deny it, I think they have aggregated their powers also to themselves. Okay, not in a not through any statute or anything, but in a way. It goes, in my view, it is also linked to what the Supreme Court has done in connection with the appointment of High Court judges. Right? The Supreme Court is now basically the entity, before central government, the Supreme Court is the entity that appoints High Court judges. And that creates an extremely unequal balance between the High Courts and the Supreme Court. Because High Court judges are essentially, in a way, beholden to the Supreme Court and are always sort of looking over their shoulder. And but it is not evident. Somebody needs to study this. I think the diminishing of the High Courts is actually linked to the power of appointment being centered in the position. And this is the other aspect of judicial independence that we need to examine, but I think another day. Because that's the reason why I think, because the High Court judges also don't know, and this is linked to the point I've made somewhere else, that every Chief Justice of a High Court, the office of the Chief Justice, in my view, of the High Courts, in my view, has reduced a lot, because it's become a transitory post, and every High Court Chief Justice is in a way looking at going to the Supreme Court. He or she does not want to take bold decisions in connection with not substantive matters. Substantive matters, I think that's a separate question. But just in terms of administering the judiciary in the state, to which he is along with his other High Court judges. The High Court is unlike the Supreme Court. Supreme Court is not the boss of the judiciary, right? They don't have any administrative powers over the High Court or indeed over the subordinate judiciary. Each High Court has the power to supervise the subordinate judiciary in that state, and the Chief Justice is an extremely important person. So on the administrative side, I feel that this collegium structure has created a lot more problems. But because it gets lost in the judicial independence debate. Anyway, I think that's for another day.
More often a subordinate to Supreme Court, not like in state judiciary or a union judiciary.
See, High Courts are subordinate to the Supreme Court on questions of law. I agree.
In respect of appointing the judges.
They are not. Constitutionally, they are not. Constitutionally, they are.
Yes.
See, a High Court judge, the High Court judge is a constitutional authority. He can't be removed. I mean, he can be removed only by impeachment in Parliament. So that even High Court judges seem to have forgotten that that they are holding a constitutional post, and they don't need to be afraid or. But see, it's not a question of fear. I believe. I think it's a question of wanting to go to the Supreme Court or wanting to become a Chief Justice. I think there are other things at play here, and in a way the High Court's High Court's administrative powers unfortunately have, I feel we need to maybe I'm saying this without thinking more deeply about this, but we need to study this a little bit.
This question is slightly exposed in the first judge's case, but not answered in the entire.
I mean, see, some things are best left unanswered. That's why they are best left unanswered. They've not answered that, but we will see how this goes. But maybe that's the reason, because Supreme Court, they can easily say no in SLPs. They don't have to accept. Actually, they accept only like 5% or so of or even less of the SLPs filed. But somehow this has happened. This sense that everything needs to go to the Supreme Court has set in, which needs to. It will take some pressure off them also.
I think if there are no more questions, we can wrap this up. Thank you so much, sir, for this it clarified a lot for me, and I'm sure it must have been the same for others. And it was interesting to sort of go into stuff that, the judgment itself didn't answer, but we could sort of elaborate.
Well, thank you. Thanks for asking me to do this. Sort of made me also think about certain issues. And I think we have got more issues now to think about after the discussion. Thank you.
Thank you all for coming.
Thank you.